Joumana Kayrouz. You've seen her images on giant billboards across the metro. Joumana Kayrouz. You've seen her images on buses across the city. Now get to know Joumana Kayrouz.
The war broke out in my home country, Lebanon. I was 11 years old, and I saw a lot of bloodshed and inequality and poverty. You can't grow up in an environment like that and not be affected by it and not want to make a difference. I graduated from Yale University with a master's in ethics. I speak 4 languages. It has always been innate in me fighting for the underdog and trying to do whatever it is I can to make a difference in the world.
Let Joumana Kayrouz protect your rights. Call the law offices of Joumana Kayrouz at 1-866-YOUR-RIGHTS extension 100 or visit yourrights.com.
قد يحاول بعض المصابين في حوادث السيارات إدارة قضاياهم توفيرا لأتعاب المحامين، والآن مكتب المحامية جومانا كيروز بإمكانه المساعدة من خلال إشرافه على سير القضية في جزئها الأول المتعلق بتعويضات الراتب والخدمات المنزلية، وتقوم بإرشادك في كيفية إدارة ملفك مجانا، بينما سيتولى المكتب مهمة الدفاع عن قضيتك في جزئها الثاني المتعلق برفع دعوى عن عطل وضرر. للمزيد من المعلومات اتصلوا بمكتب المحامية جومانا كيروز والاستشارات مجانية 248-557-3645. هل أنت مضطر إلى إشهار إفلاسك؟ لا تأخذ هذه التجربة لوحدك، بل استشر أولا ومجانا مكاتب المحامية جومانا كيروز، وتكلم مع المحامي المختص بقضايا الإفلاس مايكل بنكستين، الذي سيساعدك على التخلص من ديونك وفقا للبند 7 لقانون الإفلاس بسعر $575 فقط. ومن الممكن أيضا أن تحصل على إعفاء من أتعاب المحكمة اعتمادا على عدد أفراد الأسرة ومدخولك الشهري. اتصل الآن بمكاتب المحامية جومانا كيروز 248-557-3645 والاستشارة مجانية. برنامج يور رايتس مع المحامية جومانا كيروز المختصة في قضايا حوادث السيارات، مع نخبة من المحامين في اختصاصات عدة منها الطلاق والهجرة والإفلاس، يأتيكم الآن على الهواء مباشرة. سعدتم مساء أحبائي المستمعين في كل مكان، وأهلا بكم في هذه الحلقة الجديدة من برنامج يور رايتس مع المحامية جومانا كيروز. ودائما على الهواء نستقبل اتصالاتكم ومشاركاتكم، وخاصة في القضايا التي يتعامل معها المكتب. واليوم تخصص الحلقة لقضايا الإفلاس مع المحامي مايكل بنكستين. أرقام الهواتف في الاستوديو 313-769-6666 519-256-1023. دائما على الواتساب 313-327-7074. مكاتب المحامية جومانا كيروز تتعامل مع قضايا الإصابات الشخصية من ضمنها حوادث السيارات، إصابات العمل، الأخطاء الطبية، قضايا الهجرة والتجنس، قضايا الإفلاس، وقضايا الضمان الاجتماعي. الاستشارات مجانية عدا قضايا الهجرة والتجنس. رقم الهاتف في مكتب المحامية جومانا كيروز 248-557-3645. من تفوته فرصة الاستماع لهذه الحلقات بإمكانه العودة إلى قناة جومانا كيروز على اليوتيوب ومتابعة الحلقات الماضية، وكل ما عليكم هو المشاركة فيها في هذه القناة والضغط على زر الجرس ليصلكم كل ما هو جديد عندما نقوم بإضافة حلقة أخرى على اليوتيوب. نتمنى لكم أحلى الأوقات إن شاء الله. جومانا مساء الخير ورحب بك في برنامج رايتس.
يعطيك العافية، مساء الخير، مساء الخير لك ولكل المستمعين. هابي فرايدي يا فريد.
يا هلا جماعة.
أهلا وسهلا. شكرا جزيلا رامي. كمان مرة يا أهلا وسهلا بكل المستمعين. كل نهار جمعة بنحكي عن قانون الإفلاس مع المحامي مايكل بنكستين. اليوم رح نكمل عن الموضوع اللي حكينا عنه جمعة الماضي رامي. كنا عم نحكي بطريقة مفصلة أكتر عن الفرق بين Chapter 7 و Chapter 13 وكيف المحكمة بتعالج الديون Chapter 7 وكيف المحكمة بتعالج الديون Chapter 13. حكينا عن العالم اللي دايما بتفضل إنه تكون مؤهلة Chapter 7 وليش، وإنما في أشخاص غير مؤهلين Chapter 7 بيكونوا مؤهلين Chapter 13. حكينا الجمعة الماضية عن موضوع السيارة. الإنسان اللي بيكون عنده سيارة إذا قدم Chapter 7 شو بيصير بالسيارة؟ هل رح يصير إلها repossession؟ شو بيصير بالسيارة إذا كان Chapter 13؟ حكينا عن شيء ما كنا حكينا عنه قبل، إنه إذا السيارة الشخص مشتريها وداخل بعقد عمره أكتر من 910 أيام، يعني 2.5 سنين، كيف بيعالجوا هيدي السيارة وإلى آخره. وبآخر 5 دقايق بلشنا نحكي عن إذا نحن بتشابتر 13 وعنا ديون، والديون مختلفة وعلى أنواعها، منا secured يعني عندها أولوية، ومنا unsecured يعني ما عندها أولوية. secured مثلا مثل your mortgage، unsecured مثل credit card. كيف المحكمة بتشابتر 13 بتعالج الموضوع؟ لمين بتدفع بالأول؟ قدين نسبة الدفع؟ إذا كان إنسان بتشابتر 13 ومأخر عبيته شو نسبة الدفع؟ إذا كان لأنه بتعرف اللي بتشابتر 13 يمكن عنده $300 باقي بآخر الشهر، كيف بده يصرف هال $300 وقت اللي عنده ديون، مأخر عليه البيت، عنده كريدت كارد، عنده medical bills إلى آخره؟ كيف المحكمة بدها تاخد هال $300 and stretch it؟ أول شيء، هل رح ندفع للكل؟ هل رح ندفع على 3 سنين؟ هل رح ندفع على 5 سنين؟ هل في حدا عنده أولوية للدفع؟ هل في حدا بيندفع له in full؟ هل حدا بيندفع له in part؟ اللي بيندفع له in part كيف بتطلع المحكمة؟ هيدي أشياء رامي ولا مرة حكينا عنها بطريقة دقيقة جدا جدا جدا. خلينا نبدأ ونستقبل بالأول المحامي. Good afternoon, Attorney Michael Benkstein.
Good afternoon, Joumana. How are you?
I am good, Michael. How are you doing?
Excellent, thank you.
I think we prepared today for our show in we set a new record today. We took less than 15, 18 minutes to prepare for our show today.
Yes, I think that was about the amount.
Yes. Okay. I was reminding the listeners that last week we again talked about a little bit the difference with chapter 7 and chapter 13, but the discussion last week was mostly about chapter 13, something we've never talked about in a really great detail before. We're going to continue that discussion. I was reminding the listeners that a lot of people want to qualify for chapter 7, not chapter 13, for many reasons. Maybe the most important reason, and feel free to interrupt me here, maybe the number one reason why people want to qualify for chapter 7 is because it is a clean, you come out of it and it's a clean slate. Yes, your credit score is really down, but your bills are all wiped out. All of the bills that brought you to file chapter 7 are 100% gone. It's also a very quick procedure. It's relatively very fast. Normally, when you go through a court system, it's typically a year to 2, sometimes 3-year-old ordeal. When you file for chapter 7, it's a very quick kind of in and out 6 month kind of thing. And it does not cost a lot of money. However, not everyone who wants to be chapter 7 can be. So some people who need to file bankruptcy end up qualifying for chapter 13, correct?
That's right.
The second thing, we talked about a lot of things last week, and I really think last week's show is a show we need to rerun again. Maybe next Sunday we will rerun it. The other thing we talked about is I've always over the years heard you say chapter 13. Now, chapter 13 is different than, by the way, Rami, I want to apologize to our listeners, and Michael reminded me to say that on the radio. We are in a new building, and there is a lot of work that needs to be done on the building. We moved under less than ideal circumstances. Well, they have been working right now on changing all the doors into the building and the reception doors. So we've been living in noise for 3 to 4 days, and we probably will go through maybe even including Monday. So if you hear noise, Rami, I do apologize. They've been. Thank you. I appreciate it. So with chapter 13, you cannot get rid of all your debt, and you have to pay people you owe money to. How much? Is it 100%? Is it part of it? We will talk about that. But I've always heard you, Attorney Michael Benkstein, say over the years, if you are in a chapter 13, the court will give you anywhere from 3 to 5 years to pay what you are behind on to creditor A, creditor B, creditor C, and creditor D. I never asked you who decides who gets 3 years to pay the debt, regardless of how much that debt is, who pays over 5 years. Is it the, what do you call it, the claimant, the petitioner? Is it the petitioner's decision? Is it the court's decision? Because I'm thinking that every petitioner wants to stretch that payment plan over 5 years, if possible. So last year, and if you can pull out those numbers, I'd be grateful to you. Last year, you told us that is not a decision for you as the attorney. There is a rule, and the rule has to do with how much the income to the house where someone is filing for Chapter 13 is for the state in which you are living. I made a mistake and I said for the country, and you corrected me. It is for the state. So if I want to be a 3-year plan, it's going to depend on, I'm in my household filing, but there are other people who work in my household, but I, Joumana, am the one who am filing Chapter 13. They are going to take, before they tell me if I can repay my debt over 3 years or over 5, they're going to take my entire household's income and compare it to the median, to the middle, to the average of people who make more than my household for my household size, and people who make less than my household for my household size. And if I am above that average, then my payment plans have to be 3 years. But if I am below that average, then my payment plan can go to 5 years. Michael?
Well, it's actually, if you're above the median, then it's a 5-year commitment period. If you're below the median, you can be as short as a 3-year plan. You can propose a 3-year plan. But if you need to, you could make the plan longer, but nobody can make you be in it longer than 3 years. So below the median, 3 years, above the median, 5 years.
Okay, so Michael, I'm extremely confused. If I am below the median, isn't that all the more reason for the court to give me more time to pay my debt?
Well, actually, since you're paying a certain amount every month, if you start with what your disposable income is, you have your income, you subtract your out-of-pocket expenses. What you have left over is what you have to pay into the plan. So if you're paying $300 a month, you, the debtor, would probably rather pay $300 a month for 36 months than to pay $300 for 60 months. All that would wind up happening is that your creditors would get more money from you.
Oh, I understand. I think you touched upon something that, yes, I had a huge misunderstanding. So actually, really, you want to be in a 3-year plan if you can help it, because you're paying people less money than if you are paying 2 extra years.
That's correct, generally speaking.
So
There's situations where
sorry, Michael. So people in Chapter 13, if they have a choice, they prefer to be in paying debt only over 3 years, and then it's a clean slate after that, rather than over 5 years.
That's correct. Most people, all things being equal, would rather be in the plan 3 years than 4 or 5 if they can help it.
Okay. I thank you for that clarification. But at any rate, the decision over who is in 3 years or 5 years has to do with the average median income in the state of Michigan for a household of your size. So you can't compare your income to his income to her income. You have to see the income in that family, and you have to compare it. And if it goes below or above, it determines if you are in a 3-year plan or in a 4-year plan.
That's absolutely right.
اوكي سو حكينا عن هذا الموضوع الجمعة الماضي، انه اللي بيحدد اذا الشخص اللي هو بشابتر 13 مفروض عليه يدفع ديونه على 3 سنوات وبعدين خلص بينظف حاله وبتصير بداية جديدة مثل تشابتر 7، او إذا مفروض يدفع على 5 سنين ومن بعدها بداية جديدة، هي المدخول تبع العائلة. صحيح هو الشخص عم بيقدم، بس العائلة بينظروا على المدخول تبع العائلة. إذا شخص عم بيقدم بس عائلته مؤلفة من 5 أشخاص، بيطلعوا على معدل الأشخاص بولاية ميشيغان اللي هي مؤلفة من 5، وشو المعدل تبع المدخول تبع عائلة مؤلفة من 5 بولاية ميشيغان. إذا هو هذا الشخص بيكون تحت المعدل أو إذا بيكون فوق المعدل، هيدا اللي بيقرر إذا هيدا الشخص لازم يدفع ديونه على 3 سنين أو إذا بيدفع ديونه على 5 سنين. إذا كان تحت المعدل بده يدفع على 5 سنين، إذا كان فوق المعدل بده يدفع على 3 سنين. إن شاء الله يا رب كون فهمنتها صح. but اللي فهمته اليوم من المحامي مايكل اللي ما كنت منتبهت له، it's a question of math. كيف الإنسان اللي هو بتشابتر 7 أو كيف الإنسان اللي بده يقدم بانكربسي بيتمنى يكون تشابتر 7، لأنه التشابتر 7 بتنظف له ديونه 100%، بتمحي له هني، ما بيرد مصاري لحدا، بتمحي له هني، بيفوت عنده ديون بيطلع منه مديون بتاتا. التشابتر 13 لا، التشابتر 13 بتخفف له الديون صح، بس إذا عم يدفع بس على 3 سنين بتناسبه أكتر، يعني بينظف حاله من بعد 3 سنين من إنه إذا عم يدفع ديونه على 5 سنين، لأنه مصلحة الإنسان يدفع 3 سنين ويخلص من إنه يدفع 5 سنين ويخلص. من مصلحة كل إنسان يكون تشابتر 7 مش 13، بس مش كل إنسان مؤهل. من الأشخاص اللي هن بتشابتر 13 من مصلحتهم إنه يكونوا ب3 سنين مش على 5 سنين، لأنه بداية جديدة لهم من بعد 3 سنين مش بداية جديدة لهم بعد 5 سنين، وبيكونوا دفعوا جزء من المصاري. إجينا سؤال قبل ما نكمل، بس أنا مش فهمان السؤال، بعتذر. الأستاذ سام بيقول what if I need to shut down my business and I have someone else liquidated? Mr. Sam, in what context are you asking your question? Are you saying you want to shut down your business and file for bankruptcy? What is specifically your question? It's really unclear. Is this a bankruptcy question? Is this a business bankruptcy question? If you want to clarify, or if you are able to clarify, we very much appreciate it. Moving on, maybe we can take a very quick break, Rami, just to catch my breath. And now we're going to give an example of someone who is in Chapter 13, who makes this much a month and has this much left a month and owes debt, by way of example, to his mortgage because he was behind on his mortgage, and to credit card A and credit card B. How is he going to pay that money? Over how many months? Who does he pay first? Does he pay anyone in full? And does he have to pay everybody in full? Or does Chapter 13 also wipe out and lower his debt? We're going to be very, very specific. We're going to use a very specific example of someone who has, let's say, a mortgage he's behind on by, say, I don't know, $5,000, let's say, and owes credit card A $15,000 and credit card B $60,000. And let's say this person is in a 5-year plan or 60-month plan. So when we return after the break, let's talk about someone who had to file Chapter 13 with $5,000 behind on his mortgage and $60,000 behind on his credit cards. So he comes into Chapter 13 with $65,000 in debt. He has a 60-month plan, which is 5 years. Let's take those numbers and see what happens to the $5,000 mortgage and how much of it he pays every month. Let's see what happens to the $60,000 debt, how much he pays of that at the end of 60 months, who gets paid first, who gets paid last, and so forth. Quick break, and maybe we can start actually after the break by answering the question. And if it is a business bankruptcy, we will refer you to somebody, Mr. Sam. But let's take a quick break. Let's answer Mr. Sam as best we can and move on to a very specific example.
هل أنت مضطر إلى إشهار إفلاسك؟ لا تأخذ هذه التجربة لوحدك، بل استشر أولا ومجانا مكاتب المحامية جومانا كيروز، وتكلم مع المحامي المختص بقضايا الإفلاس مايكل بنكستين، الذي سيساعدك على التخلص من ديونك وفقا للبند السابع لقانون الإفلاس بسعر $575 فقط. ومن الممكن أيضا أن تحصل على إعفاء من أتعاب المحكمة اعتمادا على عدد أفراد الأسرة ومدخولك الشهري. اتصل الآن بمكاتب المحامية جومانا كيروز 248-557-3645 والاستشارة مجانية. قد يحاول بعض المصابين في حوادث السيارات إدارة قضاياهم توفيرا لأتعاب المحامين، والآن مكتب المحامية جومانا كيروز بإمكانه المساعدة من خلال إشرافه على سير القضية في جزئها الأول المتعلق بتعويضات الراتب والخدمات المنزلية، وتقوم بإرشادك في كيفية إدارة ملفك مجانا، بينما سيتولى المكتب مهمة الدفاع عن قضيتك في جزئها الثاني المتعلق برفع دعوى عن عطل وضرر. للمزيد من المعلومات اتصلوا بمكتب المحامية جومانا كيروز والاستشارات مجانية 248-557-3645. Your Rights مع المحامية جومانا كيروز. أعود إلى برنامج Your Rights مع المحامية جومانا كيروز. بإمكانكم المشاركة في حلقة اليوم والخاصة بقضايا الإفلاس مع المحامي مايكل بنكستين على الأرقام 313-769-6666 519-256-1023، وأيضا عن طريق الواتساب برسائل نصية 313-327-7074. جمانة نرجع لك.
شكرا رامي. مثل كل نهار جمعة بنحكي عن قانون الإفلاس شوي to deconstruct this complicated part of the law اللي هي bankruptcy، اللي هي حق دستوري لكل إنسان. There is an act of Congress اللي بيعطي حق لكل إنسان مؤهل يقدم إفلاسه. أغلبية العالم بتحب Chapter 7 لأنه الديون 100% بتنمحي، مش مجبورين نرد ولا قرش من دين عنا إياه. بس مش كل العالم مؤهلة لتشابتر 7، سو في أشخاص بيضطروا يقدموا تشابتر 13. قبل ما نكمل رح ناخد أرقام لحتى شوي نوصل الصورة لبعضنا البعض كيف المحكمة and it's generally كمان it's general information. ما في شيء من اللي بيحكيه لازم العالم تتكل عليه، لازم تتسمع، لازم تفتح ذهنها على الموضوع، بس لازم دائما تستشير محامي في هذا المجال لحتى يعطي استشارة بتصيب الفاكتس، الظروف تبع هذا الشخص، لأنه ظروف كل شخص مختلفة عن التاني. بس نحن عم نعطي معلومات بطريقة عامة. قبل ما نرجع لspecific example خلينا بس نجاوب الأستاذ سام اللي كان عم يسأل عن ظاهر business bankruptcy. Business is shutting down and the case is filed. So it's a business bankruptcy. Attorney Michael Benkstein, I know what you're going to say, but go ahead.
It is possible for someone to use a Chapter 7 bankruptcy as like a Chapter 7 business bankruptcy to help wind down the business, when you're liquidating, to the extent that you have you're personally obliged for any of the debts of the business. Sometimes if you've, signed a personal guarantee or something like that, a personal Chapter 7 bankruptcy would help you to eliminate any responsibility for the business debt. So Chapter 7, when you're winding down a business, is one of the options.
However, we do not do this in this office, correct? We only do personal Chapter 7.
That's correct. We'll do chapter, like a personal Chapter 7, occasionally depending on how the business is structured. Sometimes we'll do that in the context of a personal Chapter 13, but we really don't do much in the way of, Chapter 11 business reorganizations or a Chapter 7 business winding up the business.
And we do deal with attorneys who do that?
That's correct. Yeah, we have affiliates, so we have the capacity to do, any kind of bankruptcy that needs to get done.
Okay. Now, if this person, Mr. Sam, signed personally on some of his liability for his business, do you believe, just speaking generally, that Mr. Sam may also need a personal Chapter 7 or Chapter 13 bankruptcy to absolve him and free him from those personal liabilities where he personally co-signed or personally signed, gave a personal guarantee on some of the contracts he entered into for his business, or no?
Yes, depending on the amounts, he may need to file a bankruptcy because the whole point of a corporate structure is to insulate you personally from the affairs of the business. But for every move, there's a counter move. Particularly if it's an LLC, kind of a smaller company, sometimes a lender will make you sign a personal guarantee for it, kind of basically punching through that corporate veil. Depending on how much you owe, he may need to file a personal bankruptcy if he. So that's an important threshold question. Is he personally obliged on any of the debts of the business?
So the one thing you want to tell him is, if you have personally signed, and yes, I mean, I've signed on a lease where the landlord, I've signed on a commercial lease, for our French patisserie, and the landlord wanted a personal guarantee. I was happy to do it, no problem. But that's the kind of thing where if I have a company that is not going to absolve me of that liability because I signed personally as a guarantor on that lease, correct?
That's correct.
Okay. So like everything else in life, it's never this or that. Sometimes it's this and that. And sometimes when you are going through business bankruptcy, you may have personally guaranteed some business transactions that may require you, so that you are completely free to also file personal bankruptcy. And I know sometimes other attorneys reach out to us when somebody comes to them for a business bankruptcy, and it comes out that that client also needs to file personal bankruptcy because of all these obligations, correct?
Yeah, that's correct. We send the business bankruptcies out, but there's places where they just do business bankruptcy and they'll send us the personal bankruptcy part of it.
I will also add from personal experience, when I was signing that commercial lease, there was a clause protecting the landlord from my business or myself personally filing bankruptcy. So I waived that away. Is there anything you care about? Is there anything you care to add on that point?
See, to me, whether or not that's enforceable is an interesting question. I haven't touched upon it much because, again, I don't do much in the way of business bankruptcy. But if the bankruptcy code says that you can use the power of the bankruptcy court to reject a contract and walk away from it, I mean, I suppose somebody can put that in the contract, but there's a real question about whether or not that would actually be enforceable. I mean, that's kind of the whole point of bankruptcy.
Okay, so yes, some landlords may put this, especially in commercial leases. Your thought is, we're just thinking out loud right now. I don't know that you or I know the answer, but it's definitely something to think about and consider. If you sign a commercial lease that states that they are immune, even if you file bankruptcy commercially or even personally, if you have personally guaranteed it, the question now becomes, the bankruptcy code is an act of Congress. It's federal law. The contract signed with someone is covered by state law. And I'm not a constitution lawyer, but I think that federal law preempts state law. And now the question becomes whether this is the kind of contract that is enforceable, even though the landlord made you sign it and you signed it voluntarily and without duress. That's what you're thinking out loud, correct?
Yeah, that's correct. I mean, I don't know how you could waive a provision of the law. It's just is not something I've encountered. But what I would say is, if you see something like that in a contract, don't just throw your hands up and say, well, I guess that's it. I mean, check with an attorney, particularly if it's a business bankruptcy with someone who does business bankruptcies. It may not be the case that you've waived it.
Okay. We have a question from Estes Faisal. And it's along what we're talking about, but I believe we need a little bit more clarification. He is asking if the filing of bankruptcy allows a debtor to exit a long-term lease. So, Mr. Faisal, do you mean personal bankruptcy? Are you talking Chapter 7 or 13 bankruptcy? And are you talking about a lease like a car lease or any kind of thing? Because that changes the answer. Again, we were just talking about business bankruptcy. We're just talking about personal guarantees. Can you clarify to us, Mr. Faisal, if you're talking about Chapter 7 or Chapter 13 bankruptcy, and tell us what kind of lease are you talking about? It's a car lease. So, and again, and I think as a good student of what you teach, Michael, I think I can answer that question because we talked about it last time and even the time before. Can I take a shot at it?
Absolutely. You're my best student.
I don't know about that, but okay. So if we're waiting to see if it is Chapter 7 or Chapter 13, we know that he's talking about a car lease, Chapter 7. Okay, so let's see. If you have signed a long-term lease with your car company and you filed Chapter 7, now, if you are paying on the car, you can be filing Chapter 7 for a number of things that you don't want to discharge in Chapter 7. So maybe you are on time with your car lease and on time with your mortgage, but you are behind on credit card A, credit card B, and medical bill C. But if you are behind on your car and now you file Chapter 7, then Chapter 7 will wipe out, yes, it will, your obligation on the long-term lease. So one of the things Chapter 7 will free you of, Mr. Faisal, is the remaining contract that you have with that lease company. But wait, there is more. You can't have the cake and eat it too. When we file Chapter 7, there is a stay. You're telling the whole world, don't come to me, don't touch me, don't call me, don't possess my car that I'm behind on, don't cut my DTE energy, don't sue me, I'm protected because I filed Chapter 7. That is true. But in your case, Mr. Faisal, yes, you will be free of the lease. That's one of the beauties of filing Chapter 7. Whatever is remaining on the lease, you will be free of. However, chances are the leasing company will file a motion inside your Chapter 7, ask the court to lift the stay, to lift the protection you have, to lift the immunity you have, and get the car back from you because you can't not pay on the car, keep the car because you're in Chapter 7 and nobody can get close to you, and free yourself of the contract. So chances are the leasing company will ask the court to order you to give the car back, and now your payments are wiped. Your remaining obligation on the contract for the duration of the contract is gone, but you also lost use of the car. Michael, was I correct?
That's a great summary. That's correct. You can keep it and continue to pay it. You can get rid of it and not have to pay it anymore, but you can't, magically dump the debt on it, but keep the car. And you certainly can't, if you're not paying on it, they're not going to go 3 months, 3 months without you paying on it.
Exactly. So that's one of the beauties of filing bankruptcy is if you were in a contract that is ironclad, it will allow you to get out of the contract. But when it comes to a car, you can't get out of the contract and continue driving the car. It's just not equitable. It's not fair. It's not right. But yes, the leasing company has to file a motion because, again, when you are in bankruptcy, you are andak hasani, you are protected. So the court speaks through its orders, and for the court to speak, you have to file a motion. So the motion is what the leasing company will file to say, okay, we need the car back. He wants to wipe what he owes us for the last 5 months. He wants to get out of the contract that he has another 3 years on. Fine, but we need the car. Thank you, Michael. Going back
It's my pleasure.
Going back now to Chapter 13. So somebody is in Chapter 13. That person has to pay a little bit of money. I'm going to give you an example of somebody. Let me show you how, if it was Chapter 7, it's completely wiped out. If somebody owes $5,000 in mortgage debt and $15,000 in credit card 1 and $45,000 in credit card 2. That's $60,000 in credit card and another $5,000 in mortgage. And without going into specifics, if you file for Chapter 7, guess how much you have to give out of the $65,000? Zero. Okay? Zero. That's why people want to file Chapter 7, but not everybody qualifies. Let me tell you, if you file for Chapter 13 and you have $5,000 in mortgage that you already are behind on, and you owe credit card 1 $15,000 and credit card 2 or credit card B $45,000, you are today filing Chapter 13, same as filing Chapter 7 with $65,000 in debt. Let's tell you by the time you are done, let's say you are in a 5-year plan. You will pay less if you are in a 3-year plan. But let's say you are in a 5-year plan. Do you know how much the $65,000 by the time you are done paying after 5 years goes down to? It goes down to less than $10,000. It goes down to $9,920. Correct, Michael?
Depending on how much you have to pay at the end of the month, yes. So, for example,
Right.
if you had $300,
let's not be specific yet. I just want to first show the listeners why people like Chapter 7, because that same debt, that $65,000 debt, if you succeeded in being in Chapter 7, all of it is wiped out. You pay zero. You walk away paying zero. But if you have to be in Chapter 13, you're going to end up paying about $9,920. So it goes down from $65,000 to less than $10,000. So you only end up paying about $10,000 over 5 years, and $55,000 will be wiped out. Now we can go into specifics, Michael. So let's say someone was behind on their mortgage by $5,000. And let's say someone has debt, 2 credit card debt, amounting to $60,000, $15,000 for one card and $45,000 for the other card. And let's say they are in a 5-year plan. 5-year plan to pay that money, or a part of that money rather, is 60 months. 5 years is 60 months. Let's say this person earns money, and let's say at the end of the month, after the person, what do you say, the basic necessities, what is that term of art that you use?
Kind of your reasonable and necessary expenses, keeping the light bill on, paying for your food, washing your clothes, gasoline, that sort of thing.
Okay, reasonable and necessary expenses. So let's say somebody makes, I don't know, excuse me, $1,000 a month and is in Chapter 13. And after this person pays their reasonable and necessary expenses, they have $300 left at the end of the month. That means all they have and all the court has is $300 to pay all or part of the $5,000 in mortgage, the $15,000 in credit card 1, the $45,000 in credit card B over 60 months. Now the question is, the first thing, first of all, the person does not pay the money. The person who is in Chapter 13 sends the money to the bankruptcy trustee, correct?
That's correct.
The trustee takes that money and sends it over 5 years to this creditor and that creditor. But the first thing the trustee will do out of the 300 is get her or his fee, which is 10%, correct?
That's correct.
So now the $300 left after reasonable and necessary expenses is $300. The trustee gets their 10%, which is $30. It brings down the bottom to $270 a month, correct?
Correct.
That person, the trustee rather, on behalf of the person who filed Chapter 13, has 60 months, only $270 a month to pay a mortgage arrears of $5,000 and a credit card A of $15,000 and a credit card B of $60,000. My question to you is, how does the bankruptcy trustee now divide that 270? Let's talk first about if you have mortgage arrears, but you have a mortgage every month. Who's paying that mortgage every month? Is it the person who is now current but has arrears, or is it the trustee on your behalf?
Well, in this case, because they were behind on the mortgage on the day the case was filed, then they can't pay it themselves directly. It has to get paid inside the plan by the trustee.
Okay, so let's say I'm using an easy number. I don't think it ever is that. But let's say you have $270 a month that the trustee has to pay your current mortgage in, your arrears mortgage, and your credit cards. So let's say the current mortgage is $50, right? So now the 270, the bankruptcy trustee sends a check to your bank for your mortgage for this month of $50. Now, what comes next? We are now down to $220. Who gets paid next?
The mortgage arrears.
The $5,000.
Correct.
Now, you said to me that even those who are in a 5-year plan, it's not a good idea for them to pay the mortgage arrear over 5 years. You'd rather want them to pay it over 3 years, correct?
Yeah, I mean, every once in a while when it's a really tight plan, we'll go for the 60 months. But most of the time you don't want it to take longer than about 3 years to pay off the arrearages, because then you start catching objections from the creditor and the mortgage company says, hey, that's an unreasonable amount of time for it to take. So you're pretty much in the safe zone if you pay it over 3 years.
Okay, so now the mortgage is a secured debt. That means by the time somebody is done, they will have to have repaid 100% of the mortgage arrears. So the mortgage that's behind by $5,000, by the time this person or the bankruptcy trustee is done paying, the bank will have gotten all of the $5,000. So if you have only 3 years to pay it, they take the $5,000 and they divide it over 36 months, because we want to pay it over three years. So the $5,000, if you pay it equally over 3 years, it comes to $138 every month, correct?
That's right.
Okay, so we started with $300. First, the bankruptcy trustee takes his 10%. Now we are at $270. Next, the bankruptcy trustee pays your mortgage for this month so that you can stay in the home, which is $50. Now we are down to $220. Now, the trustee wants you to pay the house, the arrears, 100%, only over 3 years, although you are in a 5-year plan. 3 years is 36 months. So if you divide that $5,000 you owe in full over 3 years, it's going to come to $138 every month. So the trustee takes $30, sends $50 to your bank for your mortgage for this year, sends $138 to your bank, which is the portion of the arrears, will be doing that for the next 3 years. So you will be done paying 100% of that $5,000 in 3 years. Now, if you minus the $30, the $50, and $138, guess how much is remaining every month for the trustee to pay credit card A, which is $45,000, and credit card B, which is $15,000. The trustee has only left $82 a month to pay credit card A and credit card B. So the first point we want to tell people is debt is not all equal. Secured debt has priority over unsecured. Secured debt, you have to pay it in full. Unsecured debt, you can pay it in part. So your secured debt, which is your house, you have to pay that $5,000 in full. You're going to pay it over 3 years at $138, and you will have paid 100% of the $5,000. However, credit cards are unsecured debt, so you don't have to pay them in full. So listen to this. You have $82 left at the end of the month to pay $60,000 in debt over the next 5 years. If we're going to give you the, what do you call it? The censure? What do you call it? This aha moment, or this powerful line that we're going to say right now, Michael?
Oh, gosh, I say it all the time. Basically, would you like to pay $4,920 to your unsecured creditors or $60,000? I mean, you're only going to pay about 8 cents on the dollar in this scenario. That's a really great savings.
Okay, let's break this down. Instead of the $60,000, you're going to end up paying, by the time you are done in 5 years, only $4,920. So your credit cards, the $60,000, they're going to take a big hit. They're only going to get less than $5,000 out of the $60,000. Why? Because you only have $82 left at the end of every month to pay credit card A and credit card B. So the $82 per month, if you multiply that by 5 years, that comes to $4,900. So you're only paying $4,900 for the next 5 years to repay the $60,000. So $55,000 is going to be wiped out in your favor, and you're going to pay $4,920 over the next 60 months. So $82 is all you have. Now, how do you decide how much of the $82? It's not you, it's the bankruptcy trustee. I apologize. How does the trustee decide how much to pay credit card A that has $45,000 versus credit card B that has $15,000 out of $82? How does one get more? Yes, they all get hit equally. So the $82, they will be divided on what's called a pro rata rate. And the bottom line is, if all you have is $82 for the next 5 years, meaning all you have is $4,920 over the next 5 years, the $4,922, if you divide them by 60 months, it gives you a rate of 0.082. If you multiply that by the $45,000, it comes to $61.50 every month. And if you multiply that rate by the $15,000, it comes to $20.51. So you have $300 left. Out of the $300 left, your bankruptcy trustee will take 10%, which is $30. Your bankruptcy trustee will pay your current mortgage, say it's $50. Your bankruptcy trustee will pay everything you owe over 3 years to your bank in full. So that's $138 a month times 3 years. That's the whole $5,000. That only leaves you with $82. Your bankruptcy trustee will pay on your behalf to credit card A, to whom you owe $45,000, only $61.50. And to credit card B, to whom you owe $15,000, only $20.50 for the next 5 years. So when we did the math, do you know that the $60,000 in credit card that you owe, by the time you are done paying those credit cards over 5 years, do you know how many cents that they collect on the dollar? How many cents did they collect on the dollar, Attorney Michael Benkstein?
About 8 cents on the dollar.
8 cents on the dollar. So you see, Chapter 13 is a very good plan. Yes, Chapter 7 is better because you don't have to pay anything. You don't have to pay $5,000 mortgage, and you don't have to pay $4,920 in credit cards. But it's a very good plan because you no longer have to pay $60,000 to your credit cards. You're only paying them $4,920, and they're wiping out the rest. They're taking it as a loss. So you see how Chapter 13 helps people, but not all debt is the same. There are debts that are secured that the bankruptcy trustee is going on your behalf to return in full, like your mortgage, and that is unsecured credit card, like your $60,000 in credit card debt, the bankruptcy trustee will be repaying those in part at only 8 cents per dollar. So those credit cards got the bad end of the deal, but that's the law. That's an act of Congress, and there is nothing they can do about that. With the 5 minutes remaining, you wanted to also add, and again, let me repeat, we're using those numbers as an example. We used easy numbers, relatively speaking. It's never that easy. If it were that easy, you don't need a bankruptcy attorney and you can do it yourself. And I think it's a very bad idea. Very, very bad idea. But it's not that simple, but what we said is correct. The numbers we use and the way it gets divided and who pays the money and whether it's over 3 years or 5 years and what debt do you return in full and what debt do you return in part, that's all the way it goes. You wanted to add one more thing. When you are filing your tax returns and you are in Chapter 13, if you ever get a federal tax credit or a tax, a tax return or a federal tax credit or a federal tax...
The refund, the money you get back.
Refund, thank you. A federal tax refund. Not a state. The state you can keep. The federal tax refund, you have to turn it over to the bankruptcy trustee to repay your debtors, correct? Your creditors, correct?
That's correct.
And if you don't do that, you will be violating the terms of your Chapter 13 and you will not get discharged after 3 to 5 years, correct?
That's correct. And it's really important to get a discharge at the end. You have to do all the things that you're required to do to get a discharge, because if you do anything short of that and the case doesn't get a discharge, then it's not 8 cents on the dollar. You still owe all that you owe. So you got to get a discharge. That's a key thing.
Okay. So again, if there is an extra $1,000 you get on your IRS tax returns, you have to turn it over to the trustee. You should turn it over to the trustee. And what the trustee will do, the trustee will go and send extra payments to people you owe money. With less than 5 minutes, I'm going to give those examples in Arabic. So, إنسان عنده ديون لنقول $65,000. إذا قدم Chapter 7 بينمحوا كلهم، ما بيدفع ولا قرش من $65,000. إذا الإنسان قدم Chapter 13 يمكن رح يدفع منهم تقريباً $10,000 على سبيل المثال على الإكزامبل اللي نحن عطيناه. كمان it's a very good deal. بدل $65,000 نزلوا لأقل من $10,000. Not bad. Chapter 7 هي صفر. But Chapter 13 بتكون تقريباً $10,000. على سبيل المثال إنسان مأخر مورجج على البيت تبعه $5,000 وعنده كريدت كاردز بقيمة $60,000. بالأول ولنقول سلم جدلاً هيدا الإنسان عنده اللي بيسمون reasonable and necessary expenses اللي هن المدفوعات الشهرية اللي هي ضرورية، يعني مش المطاعم بس، تدفع DTE bill، تدفع الستودنت لون، تدفع الكار انشورنس. لنقول هيدا الإنسان سلم جدلاً بقي عنده in Chapter 13 وعنده دين $65,000، عنده بشابتر 13 $300. هيدا ال $300 بتروح كل شهر للبانكربسي تراستي. البانكربسي تراستي بده يقسمها بين أصحاب الديون اللي هن 2 كريدت كاردز واللي هن البنك. أولاً قبل كل شيء البانكربسي تراستي بياخد إجرته اللي هي 10%، يعني $30. المبلغ بينزل لل 270. ثانياً البانكربسي تراستي بيدفع المورجج تبع اليوم. ثالثاً البانكربسي تراستي بياخد ال $5,000 اللي هن بالمورجج والمأخر عليهم وبيجبر الإنسان إنه يدفعهم. صحيح هو إني 5 year plan بس يقسطهم على 3 سنين. إذا بدنا نقسط $5,000 على 3 سنين بيطلعوا $138. يعني ال $5,000 كلها بدنا. هيدي ضرورية جدا نعرفها. ليه؟ لأنه هيدي secured debt. ما تبقى من ال $60,000 البانكربسي تراستي عنده فقط $82 بالشهر، يعني $82 على 5 سنين يقسطهم. ال $82 ضرب 60 شهر بيطلعوا 4,920. يعني ال $65,000 رح ندفعهم فقط على 5 سنين 4,920 اللي هن أقل من 60,000. يعني وفرنا 55,000، دفعنا 4,900. البانكربسي تراستي بيقسطهم نسبياً. يعني الكريدت كارد اللي عندها 45,000 رح تاخد أكتر من الكريدت كارد اللي عندها 15,000. الكريدت كارد اللي عندها 15,000 رح ينزل الدين للشخص ل 1230 على 5 سنين، والكريدت كارد اللي عندها 45,000 رح ينزل الدين تبعها على 3690. والديون الاثنين، يعني اللي عندها 45,000 رح تحمي كل شيء ما عدا 4,000، واللي كان بدها منا 15,000 رح تحمي كل شيء ما عدا 1200. ونحن نزلنا ديوننا بتشابتر 13 من 60,000 كريدت كارد ل 4,920 دولار. So this is chapter 13 اللي بيجي هو بchapter 13 اللي بيحصل على federal income tax return، مش state income tax return. federal has to turn it over، لازم يبعثوا للبانكربسي تراستي، وإلا هي مخالفة جدية ما بتعطي أهله إنه يطلع من البانكربسي وقت اللي بيخلص البلان. شكرا جزيلا لكل المستمعين ليلي بعتوا الأسئلة للمحامي مايكل بانكستين. لإلك رامي. happy and safe Friday everyone.